Hello, welcome to Somerset News Network. I did a video on the right of free speech. Freedom of Speech and Debate, Article 9, Bill of Rights. I got some gentleman having a go at me, telling me I can't read. Well, I went to school and they sort of taught me to read. And one of the things that I'm good at is reading an Act of Parliament and understanding how that relates into action. I worked for the civil service for 6 years, and one of the things they found out was that I could read an Act of Parliament, I could understand what an Act of Parliament meant, and I could figure out what it meant in practice. And I used to be an advisor for the wildlife section because I was dealing with the Firearms Act and the Wildlife and Countryside Act. And my expertise is with country sports, how those acts apply to me and conservation. They were quite surprised that I understood. I was only an AO, I wasn't a solicitor or anything. But they asked me, what's your opinion? Well, the same principles I use for the Firearms Act and the Countryside and Wildlife Act, I apply to the Bill of Rights. Especially when you're talking about freedom of speech, it's Article 9 of the Bill of Rights. And what it's got, if you've got an act, you've got a clause in an act, and there's the word and in the sentence, it adds the two parts together, and this and that. If there's an or in it, it's either or, it's one piece or the other piece. And that's very important when it came to me. As a gunsmith, I use the Firearms Act as a backbone. That's what I've got to understand, is how the Firearms Act works. And there's lots of ands and ors in that. And there's exemptions in it. And the exceptions are ands and ors. So you've got to understand what one part means or the other part means. Now I'm trying to make this simple so you can understand. It sounds convoluted, but you know, it's like trying to explain cricket. You know, you've got 11 players on one side and 11 players on the other. One side's in the field and the other side's out, but they go in until they're out. You know, it's the same as explaining cricket. So, freedom of speech and debate, and then there's a little word that says or. So on the other video, have a look at it. That or splits it. Debates in Parliament. Now they're trying to tell us that this section only applies to members of Parliament. That's the sort of, you know, common belief they try and put forward. But they're misleading us. When you read it again and you understand how Acts of Parliament work, it's freedom of speech or proceedings in Parliament. So it splits it. So it's two sections. So you've got freedom of speech and debate and proceedings in Parliament. Then it goes on to say that it can't be questioned in any place or court outside of Parliament. Well, it doesn't say outside, it says out of Parliament. But they mean outside of Parliament, that's what it means. So it's there. Now, MPs think they got the right of free speech. No problem at all. But the problem is they can't lie or be defamatory against anybody. Because although we got the right of free speech, we have a backup that stops You're saying what you really think sometimes. And you've got to be a bit careful. And yeah, like anything, there needs to be a set of rules. And there needs to be guidelines. Even the advocates of free speech in Blackstone's understood there had to be safeguards. There had to be limits. So even if an MP thinks he got the right of free speech, he can still be taken to court for libel. But it has to be the Court of Parliament, which would have been the Law Lords. But the Law Lords are now the High Court. And that's why freedom of information, freedom of speech, ends up in the High Court. Newspapers say they have the right of free speech. When newspapers get it wrong, or they say something wrong and somebody doesn't like it and take them to court to try and shut them up, it ends up in the High Court. Because that's the Law Lords. That's what the Act of Parliament allows them to do. Lower courts can't handle it. So, MPs cannot have a right on their own. If you talk about Locke, who was around about the time of the Bill of Rights, he was on about the divine right of kings, and that the king hasn't got the divine right. The power lies within Parliament, which is the House of Commons, the House of Lords, and the Crown. Together, the three of them. So MPs can't assume that they've got this all-encompassing right to free speech. Because I think, if you read it correctly, we all have. Because if newspapers have got it and they got to go to the High Court, so have we. I made a statement on Facebook. I had a 4-month police investigation. All the way through, my defence was the Bill of Rights, Article 9, the right of free speech and debate. What I said was correct, so it wasn't libel and it wasn't defamatory. So they couldn't use that against me. They tried to use the Malicious Communications Act. So I said it's what I thought, it's factual, it's true. Because somebody doesn't like it, doesn't mean that it's wrong. And I kept spouting on about freedom of speech and debate. My lawyer wanted to say, oh, that's freedom of expression. I said, no. We're not going to use the European Court of Human Rights. We're going to stick with the Bill of Rights, the right of free speech and debate. I didn't want to use freedom of expression. And I don't think he quite understood. But in the end, he said, all right, we'll use it, we'll see what happens. It came back from the police after, I think it'd been to the CBS. No further action. He couldn't believe it. He said, I don't believe that. Now, that was Christmas last year. If it was May, June, July this year, and Starmer had got in, I think it would have been a different question. But all these people that have been making things and saying things on Facebook, as long as it's true, they got the right of free speech and the right of debate under the Bill of Rights. They're not using that as a defence, and I think they should. For one, the government won't want to have that in court because they got to uphold it, because they use the same clause within the Bill of Rights for free speech in Parliament. So they can't have a go at it, and they can't say it's just for them. because they can't be above the law. They can't have a law only just for them. The same's true about the Prime Minister using the right of the, they call it the right of the crown. Blair used it to go to war in Iraq. He has not got that right. We remove the right of the power of the king, the divine right of kings, when we had the Bill of Rights. It was first a Declaration of Rights, and there's the Declaration of Rights, and then that became the Bill of Rights, and that took the power away from the crown and put it into the hands of the Commons, the Lords, and the King. And the King's power was stripped by the Bill of Rights. You also have the Act of Settlement. That was the year later. The Bill of Rights was 1689, and then in 1700 you had the Act of Settlement, and that laid out the succession to the crown. But the last paragraph, the last part of it, says the laws of England, there you are, the laws of England are the birthright of the people, because it's the common law. It's what we work on. And everybody should read the Bill of Rights and understand it. Anyway, that's my little rant over. I just don't like people telling me that I'm wrong when I know I'm right. The freedom of speech and debate is not just for MPs. Anyway, rant over. Bye bye.